Yes.
Adjournment request from item number 1 to 4.
Please, your lordships. Lordship, I beg to mention item number 4, lordship.
Yes.
Lordship, in this matter, on the respondent side, filed an affidavit the day before yesterday. Lordship, we need 2 weeks time to file our response.
As prayed for on behalf of the petitioner, re-notify on your date after October.
14 October.
Lordship, obliged.
From item number 5 to 11, adjournment request.
May please, my lord. My lord, I beg to mention item number 8, lord.
Yes, you have circulated this one
My lord.
as prayed for on behalf of the appellant, re-notify.
16 October.
No appeal. I'm paying for listing of a writ appeal, Lord. If possible, Lord.
Adjournment request from item number 12 to 16 after that.
May please, your lordship. Lordship, I beg to mention item number 15 of today's list.
15.
Lordship. Lordship, in this case, we are led by Dr. Ashok Saraf. He has some personal difficulties today and could not come to the court, Lordship. May I pray next week any date, Lordship.
All right. As prayed for on behalf of the appellant, re-notify it. So.
23rd September. Any other request?
Wait, please, your lordship. Lordship, I'd like to mention item number 12 for adjournment.
Lordship, I have an objection regarding the adjournment. Lordship, we are the same, same respondent side. So for a set of 22 to 25 respondents, why the whole set of respondents has to suffer? There are 152 respondents and the matter is long pending since 2017. In fact, the land was occupied in the year 2004 for the construction of the Bogeyville Bridge. So we are the poor petitioners. The matter needs to be heard. Why they are taking
That's right,
adjournment?
Mr.
Lordship,
Counsel.
I have an objection, Lordship. In
You
fact,
may
the
have
appellants
an
don't.
objection.
Lordship,
may
in
have
fact, the
an
appellants
objection.
don't have any objection regarding the adjournment.
You may have an objection, but you must accommodate your colleagues. That's not that.
Lordship, they are only
If for the
representing-
second time, if they
Lordship,
take adjournment, all right.
Lordship, they are only representing 20 to 25 respondents.
That's
And
all right.
there
So
are 152 respondents
we will
in this
hear it
case.
piecemeal, Mr. Counsel. See, on days you might be in difficulty. Don't do that. You must be considerate. There would be some reason. Please take care that you don't take time on the other one.
I am for the appellant, my lord. All the respondents are.
Appellants don't have any objection regarding
This is the last adjournment that we are giving. We'll have it recorded, or even if we don't record it, don't remind us on the next date.
Lordship,
there is
kindly last chance may be given. The matter needs to be heard. It's long pending since 2017.
Lordship, my senior is sick for the last 10 days and he is not recovering. That is the reason I am.
Taken the consent from.
Yes, that is the reason, Lordship.
Lordship, we are also on the respondent side. We also needs to be heard.
Same as well, Lordship. We also have urgency, but had it not been an inevitable situation, I would not have requested, Lordship.
There's again an advisory from the bench, Mr. What's your name?
D. Saikia, Deopat Singh.
Mr. Saikia, it's good that you're interested in getting your matter heard. We are also interested in disposal of the cases. But you must accommodate your friends, your colleagues. That's the camaraderie which you must show. For one occasion or two occasions, you shouldn't be so insistent. Like,
Lordship,
this
date may be
matter is,
fixed.
a prayer for adjournment has been made on behalf of some of the respondents, which has been objected to by the other set of respondents. However, considering the ground on which the adjournment has been sought, after taking consent from the appellant, we deem it appropriate to adjourn the matter to give a date, sometimes in October,
14th October.
14th of October.
14th
October.
Lordship, it will be long. It will be long before the puja vacation, Lordship. On the month of September.
No, September we are not made. We are not saying anything, but please remind us on that day. This is the last adjournment.
Lordship, it may be recorded last.
No.
Much obliged, Lordship.
Yes.
I leave next.
May pray. Lordship, I'm praying for listing of a writ appeal, Lordship. It was filed on Lordship 18th of this month, August. If possible, Lordship, on Tuesday, the 26th. Lordship.
We don't know. That will be listed sometime. Just see the calendar and place it. Yes. Give your slip.
Lordship. Obliged.
May it please the court, Malad. I'd like to move a mention for listing of a writ appeal. Malad, this writ appeal was last heard and reserved for judgment and order in October of last year. But before pronouncement of the judgment, one of the honorable judges, His Lordship Justice M.R. Pathak, was transferred just recently.
Now, we have got a list of such cases
But
where because of the transfer or retirement of judges, the matter has remained there.
right, therefore, but I'm praying that it may be listed.
We'll have all of it listed one day or the other. Just give your slip. We'll
But I have it with me. Obliged.
Yeah, please, Your Lordship, I beg to mention item number 16.
16.
Yes.
Yes.
Respondent number 1, counsel, he has some personal difficulties, so kindly adjourn for the day.
Have you taken consent of the?
Yes, Lordship, he has taken.
Have you taken
Yes,
consent?
Lordship.
A prayer for adjournment has been made on behalf of the respondent after taking consent from the counsel for the appellant. Let this matter come up for consideration on so and so date.
23rd October.
Oblige, oblige.
Daily list for admission item 1.
My lord, with your permission, my lord,
Yes,
I am appealing for the petitioner, my lord.
yes.
My lord, we have filed, before your lordship permit me to proceed with the matter, we have
Yes.
filed a rejoinder, my lord.
Hmm.
The only thing is that in the rejoinder, certain annexures were mentioned, but inadvertently, my lord, that could not be placed on record. So I just wanted to point out that, but my lord, on the facts of the case, I just want to, there are certain subsequent developments. I just want to place that on record. My lord, the background of the case is this, my lord. In 2023, May 2023, one incident had happened
No,
where
no.
unfortunately,
Yes, that's right. That's right. Yes, continue.
yes, my lord. So
Just a minute, Mr. Gogoi,
We have not received the rejoinder copy, Lordship.
when did you file your rejoinder affidavit?
my lord, I have filed my rejoinder on, I'll just point out the date, my lord.
Have
This
you
was on
served?
19th. We have served, my lord, but I will again serve a copy, my lord. My lord, today my prayer is very simple, my lord, because lordship will see subsequently, my lord, another DP has been initiated against the petitioner, and in that DP he has been suspended.
Okay.
So there was a stay by the single judge in this matter.
Therefore, that would be a separate cause of action.
So I have filed a writ, my lord, and that is pending. The pleadings are complete, my lord. In my rejoinder, my lord, at page number 220, I have mentioned the number of that writ petition, my lord. I'm praying, my lord, since the matter, both the matter writ appeal and the writ petition, my case is, my lord, that 2023, since then 2 years, I have been kept out of office, my lord, by a compulsory leave order.
Why you not posted as principal of Jorhat Institute?
Because the High Court, the single judge stayed, my lord, that order. And during the stay proceedings, when the matter was stayed, the order was stayed, they passed a second DP and suspended me.
No,
And-
that you have said, that
Yes,
we have
ma'am.
understood.
Yes,
But this appeal is against the judgment whereby the order by which you are asked to proceed on leave compulsorily,
yes,
that was set aside. But
yes,
you're posting to a different institute, that was not interfered with.
yes,
So
ma'am.
we are called upon to decide this
Yes,
issue first,
yes.
whether this transfer is punitive or not.
Right, my lord. So therefore, my
This
lord,
would be- Just a minute.
yes, sorry,
This
sorry.
would be absolutely different from what you're now challenging in the writ petition. So that will be taken up separately. This is a writ appeal. If you want to pursue this, it's all right. We'll not have both the cases together.
All
These
right,
are
my
two different things.
lord.
It may arise out of the same incident of 2023 when seven students died.
right,
And the allegation against you was that you did not maintain right kind of discipline. You
Yes.
did not enforce the resolution which was taken a long time back in the year 2012. Those
right,
are different aspects of the matter.
right.
Now here, if you're keen on proceeding with this appeal, we are ready to hear you. The other writ petition shall be heard before the appropriate bench.
My lord,
This is the judge.
yes, my lord. I follow what your lordship falling from the bench, my lord. My lord,
Yes.
my humble submission is this, my lord, that since I have been suspended pending this writ appeal, my lord. So therefore, my lord, the order which I have challenged here before your lordship, my lord, that probably the department it is not in a position because they have suspended me. Right now, I am under suspension. I have challenged that order separately. Your lordship is right, my lord. But since I have been suspended, my lord, this order of transfer, if they make a statement, my lord, that they're not going to implement this order of transfer because I am under suspension. So this writ appeal does not survive, my lord. If they make a statement, if the department makes a statement, because this order, because it has become infructuous, then they will not. Then they will. We may not proceed with this matter, my lord. Otherwise, my lord. Otherwise, my lord, yes, sorry.
Once you're under suspension,
Yes,
you
my lord.
will be given a place of posting. You will be asked to be there, but without any work.
Yes, my lord.
So therefore, this does not become infructuous unless you don't wish to prosecute this.
My lord, I wish to prosecute this because
We are not asking the state to concede to any prayer of yours.
Very
Now,
well,
if
my
you
lord.
wish to contest this transfer,
Yes, my lord.
prior to your being suspended now,
Yes, my lord.
contemplation of a departmental proceeding, if you want
Yes,
to.
my lord. My lord, therefore, I'm requesting.
You can unilaterally withdraw this appeal. We'll permit you to do so.
No, my
And
lord.
contest that
Mi-
petition.
Therefore, my lord, I was praying, my lord, since there is a separate writ which arises out of almost because same chain of events, my lord, because these are subsequent disciplinary proceeding initiated against me, my lord. So therefore, I'm requesting, my lord, if both the matters are taken up together, my lord, that will give that. No,
That prayer is rejected. That's
very
a
well, my
different
lord.
issue altogether.
My lord, very well. In that case, my lord, I have filed my rejoinder, my lord. My learned friend seems to don't have a copy. Lordship may fix it next week, my lord. I was supposed to be present before Lordship. I feel
So we suggest to you,
Yes,
subject
my lord.
to your accepting our suggestion,
Yes, my lord.
you have a long date here,
Yes,
or
my lord.
we can dispose it off. Prima facie, we are not finding your case to be, your demand to be correct. This is a-
My lord, Lordship will give me
Many
a chance.
times, you see, you are aware of the law that it's an administrative tool.
Yes, my lord.
Agreed, it's one of the exigencies of the service.
Yes, my
But
lord.
then this could be an administrative tool also to
Yes.
ensure that effectively the institutions are managed. So if
Yes,
you want
yes.
to pursue this, all right, the better option for you is to, of course, the suggestion is for you to accept, to pursue that writ petition.
My
against
lord,
the order of suspension
I
or
take this.
initiation of a departmental proceeding.
I take the first suggestion falling from the honorable bench, my lord, that let Lordship may give me a date, my lord. In the meantime, I will place my rejoinder on record and I will pursue my writ petition in the meantime, my lord.
It appears that a rejoinder has been filed on behalf of the appellant, annexing certain documents which could not be placed on record inadvertently. The copy of such a rejoinder affidavit has not been received by the respondent state. Let this matter come up for consideration on give a date after 2 months. In the meantime, you have a copy served.
Very well, my lord. I will do that. Grateful.
Have Mr. Gogoi served a copy of the
Yes,
rejoinder.
absolutely. I will do that.
12
Grateful.
November. Item number 2 for hearing.
They have not been.
May I please, your lordship?
WP criminal, that's right. Even in a criminal proceeding, in order passed, there are I'm aware. I'm aware. So there is a judgment which I have not. In any view of the matter, the tenor of the order has. Let's see what is this prayer. This prayer is something else. Yes.
May I please, your lordship? Lordship may be pleased to peruse, my lord, order dated 15/5/2025. My lord, what has happened here, my lord? The order put in appeal here, my lord. We have obtained a certified copy, but the order was not found to be complete. It contained, my lord, lot many paragraphs which were not available, my lord, made available to us, my lord, when the certified copy was furnished. Accordingly, my lord, this honorable court, my lord, had directed an inquiry. And my lord, by order dated 15/5/2025, my lord, first in the instant proceedings, my lord, I was directed, my lord, to obtain a fresh certified copy, my lord, containing the entire judgment, my lord. Now, my lord, thereafter, my lord, on 17/6/2025, I had applied for the certified copy, but on the perusal of the certified copy, I found, my lord, the same discrepancy lies, my lord.
And even as on today, my lord, I have checked in the online website, my lord, the discrepancy is still there, my lord. That full text judgment is not yet uploaded, my lord, and not, the certified copy has also not been, my lord, furnished to us in entirety.
No, this apart, whether this appeal would be maintainable,
Yes, my lord, so far as
that apart, we'll address that issue.
my lord.
You're right. But then whether this appeal would be maintainable otherwise.
My lord, an argument was forthcoming from the other side, my lord, that under the High Court rules, my lord, which we have, my lord, it doesn't allow, my lord, for filing a writ appeal against the WTC criminal. My lord, a heavy reliance was placed by them, my lord, on the strength of her order, my lord, passed by this division bench, my lord, in the writ appeal number 370 of 2023, wherein, my lord, this honorable court had relied on, my lord, the decision of the apex court, my lord, in Ramkishan Fauzi. Now, my lord, I will be relying in Ramkishan Fauzi, my lord, to persuade this honorable court, my lord, that in essence, my lord, although, my lord, it was branded as WP criminal, my lord, but in essence, my lord, the honorable single judge has exercised a civil jurisdiction. Although it was a petition for habeas corpus, there were two reliefs sought for, my lord, for getting the body of the person and also, my lord, for seeking compensation, my lord.
That's right. You'll have many such instances where even orders which cannot be appealed against, where there is no provision for inter-court appeal. But if the tenor of the order passed by single judge
Absolutely.
is of the kind which is passed under Article 226, then appeal is maintainable. You can argue that. We have many decisions, one decision authored by me in my erstwhile
I'm
jurisdiction.
so obliged, my lord.
That's that apart. But here it is so intricately integrated with, it is so interwoven with your main prayer in the criminal writ petition, main prayer of the writ petitioner in the criminal writ. But what actually do you want? Are you contesting the quantum of compensation?
Yes, my lord. That's
Why?
what, because, my lord, under the scheme, admittedly, my lord, that scheme was placed before
Forget
the.
about scheme. If the order has been passed under Article 226,
No, my lord, that will lead, my lord, open floodgates, my lord, because lot many similar matters are coming, my lord. My lord, I will place a decision, my lord. Lot many similar
it's a
matters.
reasoned order.
Yes, ma'am.
Therefore, we may not be able to segregate this part. So it's basically it's basically an order passed in criminal writ petition, habeas corpus petition, and compensation which is inherent with the powers under Article 226.
No.
Examine that aspect, come back to us. We don't think you have a case in appeal. And the amount is not something extraordinary.
My lord, with all respect, my lord, the findings of the honorable single judge in arriving at that
That's
quantum.
different.
No, my lord.
The moment you question that,
My lord.
then this appeal is not maintainable. You ask about the correctness of the amount of compensation, but is that justiciable? Unless it shocks unless it brings the entire state to a financially straitened situation.
That is
Somebody was kidnapped, he was killed, nothing was done. You're a welfare state.
That is true, my lord. But, my lord, if I may pray today, my lord, if I may have the complete text of the, my lord, judgment. my lord.
That you must. Otherwise, also, this is for the
Lord, I can at least.
administration of the High Court. Now, we need to see. Do we ask the Registrar General for a report?
There is a direction on. The report has already been furnished. After the direction also, there is a department that is connected against the planet. And there are certain directions in the legal study that if after this order over, there's not. Here in the record. There is a notification after this judgment. Where is that? There is a notification. How to which will certify completion. It is approved for an- Okay, okay, okay. Oh, sorry. Yeah.
The copy of the certified copy which was given to you after all this, that also is not approved.
Kindly peruse this, my lord. Contain the same, my lord, 20 number of paragraphs. It ends at paragraph number 20.
The correct copy has not been uploaded yet, my lord.
Yes,
I've
my
checked
lord.
yesterday, my lord.
Right now also, my lord, I have checked it in my tablet, my lord.
Original has been declared. Oh, why have not uploaded? No, no, that is fine, but after the order part.
The investigation is complete now.
After 15/5, what is directed them to give the correct original certificate? In fact, my lords, strangely, my lords, the SCC copy, my lords, earlier, it had 30 paragraphs, my lords. A person to what transpired in the court, my lords, Now I've checked the SCC, then it's again the wrong copy has been uploaded again and the GLR has been changed. My lord, to check, there are 30 paragraphs, my lord, in the earlier GLR citation downloaded from SCC online. My lord. But I have checked yesterday, the copy has been changed again. Now it's the wrong judgment which has been uploaded. And I provided a chart, my lords, the discrepancies pertaining to the judgments. It's not a case of mere deletion, my lords, or a error in copying. There's something more to it, my lords. Things have been added, my lords, in the judgment, my lord. If my lord peruses the
Frequent situation has arisen in this case where the correct copy of the judgment of the learned single judge has not been uploaded. A habeas corpus petition had been filed seeking the production of the body of one Santosh Dam, who was kidnapped by members of an unlawful organization, who remained untraced for a long time, and for which FIR also was registered later. The records reveal that in order to secure his release, the family members of the abducted person could arrange for 20 lakhs of rupees, which was paid to somebody claiming himself to be an agent of such organization. While dealing with the writ petition, the learned single judge found that though the state was not solely to be blamed, but then there was some negligence / dereliction of duty on the part of the state police, which resulted in loss of life after the abductee was kept in confinement for a long time. In fact, it could not also be found out whether the abducted person was killed. The presumption of his death was inferred for the reason of passage of 7 years without any information regarding his whereabouts. The matter doesn't end here. The issue doesn't end here. The learned single judge found that the payment of compensation to the next kith and kin of the victim under the scheme, namely an amount of rupees 3,000, 3 lakhs, was too meager and directed for payment of rupees 20 lakhs as compensation. The aforementioned judgment of the learned single judge passed in WPCR 3 of 2007 is sought to be challenged primarily on the ground of primarily on the question of the compensation amount which has been ordered by the learned single judge. An objection was initially raised with respect to the maintainability of the writ petition, maintainability of this writ appeal, as no writ appeals lie against orders passed by criminal court. The present, the impugned judgment, the proposed impugned judgment has been passed in a habeas corpus petition. Be that as it may, we are beset with another disquieting fact that the certified copy which was uploaded is not in accord with the original judgment. When this matter was brought to the notice of this court, this court by order dated 15/5/2025, expressing its dissatisfaction over the functioning of the registry, directed for an inquiry in the matter. Directed for an inquiry in the matter. The inquiry report also has been taken into account. Nonetheless, what disturbs us even further today, that even when second time the certified copy of the judgment was handed over to the counsel for the appellant, it was not found to be the original judgment. Several paragraphs of the original judgment did not find place in the certified copy. We are at a loss to understand as to how this has happened. The Registrar General of the Guwahati High Court is directed to look into the matter and apprise us as to why even today the correct copy of the judgment has not been uploaded, and a wrong certified copy and an erroneous certified copy has been handed over to the counsel for the appellant. The Registrar General shall furnish a report afresh to this court and would in the meantime also ensure that the correct certified copy of the judgment is handed over to the counsel for the appellant.
The respondent as well.
To the parties, namely the to the learned advocates for the parties. On the next date, apart from adjudicating the matter on merits, we would also consider the issue of maintainability of the present writ appeal. Let this matter come up for consideration. Give it date in October.
May I just,
Not 10 lakhs.
may I just point out this one aspect, my lord?
Just a minute, let's have, this is something like Alice in Wonderland. I'm surprised how this has happened. And
Exactly.
it is reported in National Journal.
Yes.
Now, this
And my lord,
speaks badly of our High Court.
And-
We'll have it corrected.
one thing is very disturbing.
Please, as officers of the court, you please bear with us. Let us see what is to be done. Let us see, let us not put blame on each other.
No, absolutely.
We must straighten this out. Let's see what can be done.
My lord, absolutely, my lord.
14th October.
Deeply obliged. Very great.
I'm so obliged.
Item number 3.
May I please your lordship, before my learned counsel start, lordship, Mr. Kiali is out of station, lordship. So what can be done, lordship, is today they can start their part. We'll
We
submit on
don't
some
believe
hard
in that kind of an argument.
Lordship,
Tell me one thing, this input tax credit, there is a judgment by Madras High Court.
Lordship, 16(2)AA, no, none of the high courts in India has considered.
No.
16(2)AA, Lordship.
16(2)AA.
Lordship, 16(2)AA was introduced with effect from 1/1/22.
That's
On
right.
the last occasion, Lordship, when this our honorable High Court,
Yes.
wide order dated 27/2/25, there were 3 pairs in my petition before your Lordships. First was 36(4), which because this court has already declared it to be
I've
valid,
seen that order.
Lordships, and the 16(2)C was read down.
Yes.
For 16(2)AA, Lordships, detailed arguments were passed on, and after hearing the sides, the Lordship, the bench was convinced that yes, it has to be heard further, because the other side was, other side arguments were also to be given.
Have you examined the judgment of Madras High Court in D.Y. Bethel
Yeah,
Enterprises?
Lordship, D.Y. Bethel is a case, Lordship, wherein 16(2)C per se, that was a case, Lordship, wherein if the supplier is not paying the taxes, the recovery will be made from the recipient or not.
Yes.
Lordship, that judgment was relied by Calcutta High Court in the case of Suncraft, which went up to Supreme Court. I was appearing in the Supreme Court also, and the Supreme Court dismissed the departmental SLP on the grounds of monetary limits as well as on merits.
Okay. So now.
So 16 to AA parcel, Lordships, it's a particular clause, and the problem is in the clause itself.
What does it say?
Lordship, 16 to AA. Lordship, I have prepared a compilation of all the relevant legal provisions, which I would be going through. That would be.
Give a copy to him also.
Lordship, I have. My Lords may take page 1. It's a compilation of the relevant legal provisions. Lordship. Page 116, section 16. Section 16, subsection 2. Notwithstanding anything contained in this section, no registered person shall be entitled to take credit of any input tax in respect of any supply of goods or service or both to him unless, clause A, he is in possession of a tax invoice or debit note issued by the supplier registered under this act or such other tax-paying documents as may be prescribed. If this is clear, I should be in possession of a tax invoice. To avail a credit, section 34, rule 46 defines what is a tax invoice. Clause AA. The details of invoice or debit note referred to in clause A has been furnished by the supplier in here the statement of outward supplies, and such details have been communicated to the recipient of such invoice or debit note in the manner specified under 37. Now, Lordship, we have to read this clause in two parts. The first part says the details of invoice or debit note referred to in clause A has been furnished by the supplier in his statement of outward supplies. Lordship, section 37 deals with a statement of outward supplies, which is GSTR 1. Lordship, the law, when it was introduced in 2017, it was on a different footing, but what actually cropped up because of technical issues was a different law. So, Lordship, GSTR 1 is a return, is a form which every supplier of goods or service has to file on 11th of the subsequent month, showing the details of the sales or the supplies made to a customer. Lordship, there can be two categories of customer. One is a registered customer, which we call it as a B2B transaction. Another is the unregistered customer, which is the B2C transaction. Lordship, the law says under section 37, read with rule 59, that for B2B supplies, the invoice level details have to be uploaded. That means, Lordship, if I am a supplier, I am supplying certain goods, then I have to enter in my return my invoice number, my invoice date, and the GSTI number.
Yes.
That GSTR 1, as soon as I file, it goes to GSTR 2A, which is now GSTR 2B of my recipient. So, when the law was introduced with this concept, when I file a return, it goes to my recipients 2A and 2B, and that was editable. That was envisaged to be editable, I would say. Then my recipient could have taken actions on the same. He would have accepted the credit. If he says, okay, it is not my credit, he could have rejected the credit. And if some invoice is not auto-populated, he could have added an invoice also.
Okay.
But somehow GSTR 2A, 2B became non-editable because the GSTN could not bring that IT infrastructure in place during the introduction of GST. So, Lordship, then after GSTR 2, which was to be filed by 13th, to be edited by 13th, there was a form called GSTR 3 to be filed. Now, what was the 3? 3 was a summary of 1, my total supplies tax value, and whatever input is flowing from GSTR 2. 2A, once I file 2A, it would have become GSTR 2. So, my total output tax, my total input tax, balance payable in cash, I had to pay through GSTR 3. That was envisaged. But because GSTR 2 couldn't come in place, so 3 also couldn't come in place. So the government came up with a mid-gap arrangement, something called a GSTR 3B. So we only had GSTR 1 and GSTR 3B, wherein the government said, okay, you only give a summary of the details of your total output liability as per 1, and whatever input, it is coming in 2A, not coming in 2A. You do a self-assessment under section 59. And this matter went up to Supreme Court in the case of Bharti Airtel. Supreme Court stated 2A is just a tool It's a viewing tool. You cannot take credit basis 2A. You have to take your credit under section 59 self-assessment as per your books of account. So the SSCs were taking the credit as per the self-assessment under 59.
All right, you're good that you've given this compilation. We will have a look at it. And then other side, when
There are judgments also which I'll place on the right, Article 14 and those parts.
that would be necessary only during the course of the argument.
Look,
Now, basic concept has to be clear.
the basic
So
concept, that is why
you challenge the constitutional validity of 16(2).
2AA. Double.
That's right. Yes, when would you be available?
Lordship, any date that would be convenient to your lordship.
That's 16 September is subject to your lordship.
September, we are absolutely full. That's the problem.
Then I leave it.
It'll go to October first week, second week, whichever date.
Lordship.
I leave it.
As prayed for on behalf of the respondent and agreed to by the counsel for the appellant, re-notify on, give a date on a Thursday in October. Maybe first week, second week.
16 October.
Much okay. Grateful to.
Item 5 to 7.
Item number? This is with respect to what?
Land acquisition complex.
It took time, yeah, right?
ये टाइम नहीं लिया, ये पहले का टाइम है.
Yes.
Lord, here last occasion, my lord, there is a question from questioner as my lord, whether this writ appeal is maintainable or not, my lord. Because learned single judge, when passing the order.
Give us a minute. Just tell us what has happened.
When judgment was passed, my lord, there is one, my lord, CRP, civil revision petition was there.
Louder, we can't hear you.
My lord, I filed one CR civil revision petition against the order of the execution court. And the consequence, the order was passed by district collector regarding the payment under section 34 of the relevant act. And I also filed another writ petition challenging the subsequent this order of the district collector, where it was 34 intervals was given. But when both matters are together, and ultimately this order was passed on 1st of June. 1st of June 2023. This is the page 111, the relevant. Page 111, my lord.
Yes.
This order will dispose of the both CRP 2 of 23 and WBC 19 of 2023. The petitioner Union of India has filed CRP number 2 of 23 challenging the order dated 26/10/2022 passed by learned judge perspective from additional district and session fellowship Mizoram in CMA 16 of 2022 in connection with the execution case number 1 of 2018 arising out of LA case number 42 of 2015
Petitioner have also challenged the consequential order that is 11/11/2022, 2022. Next app passed by the district collector awarding the respondent landowner's interest under section 34 of land acquisition act so from the date of possession of their land till the date of judgment and order of the reference court and the case number so and so. In WBC number 19 of 2023, the petitioner Union of India has also challenged the order 11/11/2022 passed by District Collector Kolasi, whereby landowner were found to be entitled to be given statutory interest in under section 34 of LA Act from the date of possession, that is from 4/3/2013.
No, tell us what are the issues. Now, first, whether the execution court could have come to a finding that landowners are entitled to payment of interest.
No, my lord.
That issue has been decided.
No. The execution court has this 34 interest, my lord. There is one there.
You do one thing, you give us a list of dates
Yes, my lord.
and the exact position on fact
Yes, my lord.
by the next date.
Yes,
In
my lord.
fact, you give it by Friday. No, today is what day? Thursday. Give it by next week. We'll hear you on the next week.
Next week, my lord.
Give us the list of dates because there are so many petitions filed
Yes, my lord.
by each of you. And share a copy of that list of dates
Yes,
separately with short notes
yes, my lord.
to him also.
Yes, my lord. My lord. Once again, on 29.
We have not been able to understand what is your claim.
My claim is
So
my
we need to have it, we need to read it on our own before hearing you.
yes, my lord. My claim is
So
my
you have
lord,
to tell us,
my claim is my lord. We have paid the initial award, my lord. Section 11 award.
give a
Yes.
proper background
Yes,
of the case.
Yes, my lord.
Since the time it was notified,
yes.
land acquired, what
Yes.
was the payment? There are many respondents.
Yes, my lord.
Now, some of them, they went in reference and therefore you, without going into reference, something was done.
Yes, my lord. Yes.
Give us a detailed
Yes,
sheet.
yes, my lord.
You can also do that
Yes,
from
my
your
lord.
side.
In fact,
If you're defending the judgment, no,
yes, my
you're
lord, in
defending
fact,
the judgment.
in
So it's
fact, I
better you
thought-
give it.
I thought, my lord, this will fall from your lordship's, my lord. I prepared a list of dates for my convenience. If your
Give it
lordship,
to us.
practically, my
Because
lord,
the impugned judgment is rather cryptic.
Yes.
It does not talk about the background facts.
Yes, my lord. Well, only one thing you have to notice is that my lord, so far the elephant award which was paid immediately, that was
Basically-
not reflected. But our
basically, my
cases,
lord. Oh,
our cases, my lord, so for 34 interests, these interests, my lord, is on the compensation, my lord. This,
You give us a short note,
yes, my lord.
which would be self-explanatory,
Yes,
and then we hear you.
yes, my lord.
All right, otherwise we are not able to
Yes,
even
yes,
understand what is
yes,
there,
yes,
the
yes.
judgment, what is your claim, what is not, what
Yes,
is
ma'am.
being contested.
Yes, my lord.
Prima facie, we find the order to be correct, but let's see,
Yes, my lord.
let's see. You give your notes not exceeding 10 pages.
Only the last question, and then the question was whether this, there is because order was passed, my lord, there.
The question of maintainability we will consider.
Yes, my lord.
We will consider. You will have to address us
Yes.
on that also.
Yes, my lord.
Let's see.
Yes, my lord.
You make a short note
Yes,
of
yes.
10 pages,
Yes, my lord.
right?
Yes, my lord.
Are we asking you to, are we asking you for too much?
No, my lord, no. My lord. And on 29, my lord.
9th of September.
The land council for the parties are directed to give short notes of their respective arguments for, before the matter is taken up again. Re-notify October.
October. 23rd October.
23rd.
Your list of dates, Mr. Council, is also not very
lord,
specific.
my lord, that is, my lord, for my convenience, I
That's for
prepared.
your convenience. Make it for the convenience of the bench also.
Next, 23rd. Hello.
It's only rarely that we require such notes.
And-
We are not,
My lord, another
the
thing is-
background facts are not there.
Well, another thing is the item, the
Next item.
5, 6, 7, 7 is there. There is, my lord, I filed a petition for my paper publication, my lord. It was, there is a.
First, give your notes, then we will decide.
Yes,
Publish me.
I left.
Item 9 to 11.
ये पेंशन दे रिटायर उन लोगों को बेनिफिट नहीं लिया अरुण गोयल गोयल
Yes,
Please, your lordship. Lordship, pursuant to my lord's direction, my lord, I have filed an additional affidavit, my lord, on 12th of this month, bringing on record, my lord, the certified copy of the judgment and order passed by the honorable single judge in the original writ petition, my lord.
okay.
Since, my lord, this is basically an appeal against the order passed in review, but nonetheless, my lord, we have.
No, you must have impugned the original judgment.
Yes,
also.
yes, impugned the original. also.
Normally, when you challenge an order of review, because review, they would not have done it. So therefore, both the orders.
Yeah.
Yes,
Now the certified copy is before this honorable court. Now, my lord, my limited ground of agitating the
let us
judgment,
see the original order.
my lord.
It should be here somewhere.
oh this was here
Lordship will also find it in the additional affidavit.
Just a minute.
My lord,
or 28 for 2016
absolutely, my lord.
Huh?
That's the judgment. It starts from running page 220, my lord, in my,
119
yes, 119 in the memo of appeal.
Huh.
But nonetheless, my lord, in the additional affidavit, my lord, I have again incorporated it. My lord.
So you rely on Amarnath Goel.
Amarnath Goel. That is my only, technically, my lord, this will be my only limited ground. Because otherwise, my lord, facts are not disputed, facts are admitted. Now, my lord, whether the state was within its competence, my lord, to fix a cutoff date. Now, Amarnath Goel says, my lord, that the state is within its competence to fix the cutoff date on account of financial stringency.
And those details were missing. Therefore, the court said that it cannot, you cannot take shelter of that.
Yes,
Now, the power the state has,
My
the recommendation of the commission, pay commission,
my lord.
the cutoff, it has to be accepted, but the cutoff date is in the domain of the government. And it depends on many other factors. That
Right.
is what state of Punjab versus Amarnath Goel says.
My lord, my lord,
Different from what DS Nakara actually said long time back.
my lord.
That's right. So what financial circumstances?
Yes.
This is for, you deny the benefit of arrears of pay for people who retired from service from 1/1/2006 to 31/3/2009.
Absolutely,
Is
my
that
lord.
correct?
Yeah, absolutely. That's it. Now, my lord, lordship will kindly appreciate, my lord.
We have
Lordship,
noted that in our order dated 24/7/2025.
now, my lord, initially, we had filed a writ appeal before this honorable court. Then in that writ appeal proceedings, my lord, we have filed an additional affidavit because this question was put by the bench at that point of time also. So therefore, lordship may kindly come to page 135 of that paper book, my lord, memo of appeal. There we have filed an additional affidavit
Hmm.
to show, my lord, what is the financial involvement.
135.
Page number 135, it will be paragraph number 4, my lord, that third line.
Hmm.
$47.62 crore. Now, this figure stood, my lord, on January 2018, when we had filed this
No,
additional.
but this is quite a vague statement. Now, 47.62 crores is a tentative assessment of yours. It is succeeded by, you qualified by saying that it will open a floodgate. This 47.62 crores, if that is the amount which is to be disbursed by you for including these people who retired between that period which you have excluded, this would not be financial stringency.
Well, yeah,
But you say that if you allow this, it'll open a gate for others.
and,
Now, where is that statement? Who all, which, how many numbers? This statement is absolutely vague for
absolutely.
you to come within the category of the case of Amarnath Goel.
Yes. Now, my lord, one other aspect of the matter, with all respect, my lord, page number 146, how this
No,
financial.
you first deal with this, no?
Yes,
We will
yes,
proceed,
yes,
we'll
yes.
proceed
Lord,
further.
yes, yes.
You deal with this first.
That is not there, my lord. Explicitly, we have only made a statement, my lord. We
So
have not
this-
exemplified it.
It was for this reason that the review was dismissed.
My lord, there is one another aspect of the matter which I will be failing in my duty if I do not point it out.
Now,
Now,
unless you point out that the figure would be staggering,
yes,
we can consider Amarnath Goel.
no, my lord.
Otherwise, it has been a long time when the judgment was passed
Yes.
and review dismissed.
Yes. Now, my lord, in the meantime, Amarnath Goel has also been distinguished, my lord, by the Honorable Apex Court. That decision I will be placing, my lord.
Yes, subsequently, reverting, almost reverting back to. But
It is a contra decision for me, but I will have to place it, my lord.
Please.
My lord, that is, my lord, 2020 14 SCC 625. I have 2020 14 SCC 625. All Manipur pensioners.
Amarnath Goel discussed there.
Discuss.
rely on the charges.
What?
That's what. The district judiciary.
उसका मतलब. Take us to the relevant paragraph.
Yes, Lordship may kindly come to my lord. Paragraph number, my lord, 4.2. At page 630, my lord, classitum C.
No.
Classitum C. Then, my lord, paragraph 7, my lord. Paragraph 7.2, my lord. My
One
whole argument.
one second, one
My lord, my lord.
Yes, read paragraph 7.
My lord. The short question which is posed for consideration before this court is whether in the facts and circumstances of the case, the decision of this court in DS Nakara shall be applicable or not. And in the facts and circumstances of the case, and solely on the ground of financial constraint, the state government would be justified in creating two classes of pensioners, namely pre-1996 retirees and post-1996 retirees for the purpose of payment of revised pension, and whether such a classification is arbitrary, unreasonable, and violative of Article 14 of the Constitution of India or not. Now, my entire argument will fall, my lord, in view of paragraph 8.2. 8.2.
So financial stringency is one aspect of the matter, that is with respect to the list, I mean, cutoff date. Now here, it is one class only. They all belong to one category. But they have retired. And thereafter, you have paid everything.
No, my reliance on Amarnath Goel stands negated by paragraph 8.2 and para 9 of all monitors. I have to fairly, my lord, submit before this honorable court. My lord.
Any other ground that you can raise?
My lord, I will not travel this honorable court and my lord, waste the precious judicial time. I have some other grounds, my lord, that is not.
That's the only ground.
My lord.
We are dismissing this appeal.
My lord, I'm so obliged, my lord. My lord, and the connected two matters, my lord, are similar, but that relates to, my lord, incorporation in the revision of pay rules. So lordship may be pleased to hear those matters on a different date, my lord. I'm not prepared today, my lord.
Okay.
My-
The other two matters to be listed in October. Let these matters to be listed. Let the other two matters be listed. On
10 and 11.
10 and 11, my lord. After 4 weeks, my lord, if
23rd October.
23rd of
Okay.
Item 13,
I'm obliged, my lord.
Yes.
Yes, but may please, your lordship. This application, my lord, this writ appeal is directed against the judgment of this honorable court, my lord. Single judge, my lord, where that. In fact, your lordship, initially there was a 145 proceeding, man.
145 initiated at whose instance?
At instance of the private respondent. At the instance of the private respondent.
No. Tell us the name.
The name, my lord. Name of the parties as my lord. First party is Subhas Basudev, my lord.
Subhas Vasudev.
And second part.
Who is the appellant here?
No, my lord. Sushil Kumar Basudev is the first party. Sushil Kumar Basudev is the first party. And the second party is Subhas Basudev, my lord.
So what happened?
Then 145 proceeding way back in 2001, my lord. The magistrate, my lord, declared in my position in my favor, my lord, that your lords will find at page 121, my lord.
Page 121.
Yes, my lord.
Then additional.
That another fact, I so satisfied that declared a position on favor of the second party until evicted by due course of law. I hereby withdraw the attachment order dated so and so. I also receive my appointed.
So it was done in favor of second party, that is Subhash.
Yes,
the
lord.
appellant.
Yes, my lord. Thereafter, what happened, my lord? Then he filed a civil suit, my lord. For possession, my lord.
That's true. The magistrate could not have decided possession, title.
Title, my lord, actually it is a annual personal line, my lord.
Civil suit for what?
For disposition, my lord. For declaring possession, they have
Not possession, that the civil suit would have been for declaration of title.
title.
No, my lord. Civil
Yes.
suit was, my lord, on the basis of that year of order of 2001, my lord. In 2008, the government tried to dispossess me, my lord. Against that order, I filed a civil suit.
Anyway,
Not seeking any declaration, my lord.
Not seeking
Not
anything.
seeking anything.
that, my lord, in
Just a
the
minute,
It's
Mr. Counsel.
Patta land, my lord.
Let's have-
annual personal line, my lord. Then thereafter, there was prayer for injunction that was rejected, my lord. And against the order of the executive magistrate, my lord.
Let us see the memo, the plaint of the civil suit.
Civil suit plaint, I mean, no? That is.
Judgment in decrease there.
Page 37, my lord.
That
Page
page 37, my lord.
37.
37.
Yes. Let us see the prayer there.
Prayer by declaring the order dated 46, 19/1/2008. Handing over possession of the suit land to defendant number so and so, Subhash Basudev, by declaring the boundary wall as arbitrary, illegal, and without jurisdiction in operative law.
So this, what happened? Title suit dismissed.
Dismissed, my lord. The injunction petition was filed, that was also dismissed, my lord. Now they file before the session judge filed criminal revision, my lord, against the this order passed by the executive magistrate, my lord, declaring position. That was also dismissed. And they came before the High Court also, that was also dismissed. Now what happened? There is a direction of this, one direction issued by the SDO, my lord, civil, my lord, on 19/1/2008, my lord. There, my lord, there was a further direction to hand over position. That was challenged in the writ petition, my lord. That was. No.
I don't think you are stating the correct facts.
May I place the facts, ma'am?
Yes, please.
Well,
You're not stating the correct facts.
No, the
Mr.
facts no, there was a direction, your lordship, I kindly. My lord,
Yes, you please tell us.
I filed the case under 145, my lord.
You are Sushil.
I am Sushil, my lord.
Yes.
I filed the petition under 145.
Yes.
My lord, by order dated 3/12/2001, passed by the executive magistrate, my lord, possession was declared in his favor.
Ah.
Now, in that order, there is no direction to hand over possession to him. It is not his case that he was dispossessed within that period of 2 months, my lord, as required under 145, my lord. Now, my lord, in 2008, 19/1/2008, my lord, the SDO passes an order.
This order under 145 was
Yes.
passed on which date?
That was passed on, my lord. 3/12/2001, my lord.
3/12/2001.
3/12/2001. Now, I challenged that before the learned district judge. That appeal was dismissed. I came up before this court, my lord. That revision was also dismissed, my lord. Matter stands stood at that, my lord.
So therefore the possession was with Vasudev.
Possession was declared in his favor.
Yes.
Now, in 19/1/2008, my lord, the state authorities, my lord, the SDO, passes an order, my lord, directing that the possession should be handed over to him.
In which proceeding?
In no proceeding, my lord.
Why?
Relying on that order of 2001, my lord.
No, can't be.
That is
order,
what-
that order loses its force.
That was the order challenged in the suit, my lord. Injunction was not
Just a
granted.
minute. So SDO passed an order on 19/1/2008
8, my lord.
for handing over the
Handing
possession.
over possession.
Uh-huh.
So that was challenged in the suit, my lord.
Who challenged it?
I challenged in the suit, my lord. My lord, during the pendency of this suit, my lord, another order came. That is.
But was it challengeable in?
No, my lord.
I think you chose a wrong forum.
I chose the wrong forum. I have to have come up before this honorable court, my lord.
Yes.
My lord, then on 17/9/2015, another order was passed that since the injunction has been rejected, my lord, the possession should be handed over. A direction was given to the police, my lord. Against that, I came up before the honorable, this honorable court, my lord. And the learned single judge has held that he could not have relied upon the order of 2001 to issue an order dispossessing him. Because if had he been dispossessed in the meantime, he ought to have filed a fresh proceeding under 145.
And no, not even fresh proceeding.
Maybe a
This-
suit.
this- in the
And liberty has been granted in the
the period for 145 is limited.
limited, man. If your lordship, I kindly take your lordship to the judgment, my lord. The operative part at page 96, my lord. Because we are agreed by that last direction, man. Your lordship, I kindly come to page 96, man. Paragraph.
No, you're not stating the facts correctly. Rather, on the other hand, your adversary is.
Yes, well.
Yes, which page?
Paragraph 12, my lord, comes the finding. My lord, honorable, page 96. 96. Honorable single judge has narrated the facts, my lord. Then findings come from paragraph 12 at 96, my lord. May I just read, my lord?
Yes.
From the materials on record, the issue which arises for consideration is as to whether the impugned order could have been passed by the respondent number 3, thereby directing the respondent number 4 to hand over the possession to the respondent number 5, when in the order dated 22/8/2001, there was no direction by the respondent number 3 to hand over the possession.
The materials on record already discussed herein above clearly show that the petitioner had filed the said proceedings being MR so and so. The said proceedings culminated with an order passed by the learned executive magistrate, thereby declaring the possession in favor of the respondent number 5 until evicted by due course of law. The tenor of the order therefore can be assumed that the respondent number 5 was in possession of the disputed land. However, the respondent number 5 had not filed any application thereafter seeking initiation of proceedings under the provisions of 145 to the effect that the petitioner had been dispossessed the respondent number 5. It is also apparent from the perusal of section 145 of the CRPC that the said proceeding has to be initiated within a period of 2 months from the date the person alleging dispossession has been forcefully or wrongfully dispossessed. Under such circumstances, it is therefore the opinion of this court that the respondent number 3 could not have directed the respondent number 4 to restore the possession of the respondent number 5 on the basis of the order dated 22/8/2001 passed in MR so and so, which was signed on 3/12/2001. Consequently, the impugned order dated 17/9 passed by the subdivisional magistrate at Sankartab is hereby set aside and quashed. However, liberty is given to the respondent number 5, if so aggrieved, to proceed in accordance with law seeking eviction of the petitioner, and the observations made herein above shall not affect such proceedings if so initiated.
So we agree by the last part of the order.
Now, tell us again, this title suit was filed against what? For what?
The title suit was filed challenging the order dated 19/1/2008.
19/1/2008 of what?
19/1/2008, that order, your lordship will find at page 32.
What is that order?
That is an order passed by the subdivisional magistrate of Ojai, directing the officer in charge of the Lumding police station to hand over possession of the land to him.
Pursuant to which proceeding?
No proceeding.
Based on the proceeding?
Based on that proceeding.
So you filed a title suit there?
I filed it.
That was dismissed?
Injunction was rejected, my lord.
Injunction was rejected. Thereafter?
Thereafter, fresh order was filed.
Appeal remained pending. The
No,
suit remained pending.
Suit remained pending.
What has happened to that title?
Suit, my lord, as of date, I had instructed my client to withdraw the suit, my lord. Whether it has been withdrawn or not, my lord, that I'll not be able to apprise the lordship right now. But I had instructed him to withdraw the suit. It was definitely before the wrong forum, my lord. We should have come before this honorable court, my lord. Now, the order impugned in the writ petition, lordship will find at page 78.
So your being dispossessed is not on record. You have always remained in possession on paper. If you're dispossessed, you file afresh.
No, I'm not being dispossessed, man.
Then what is the problem?
Problem, my lord, what has happened, my lord? In view of the last line, my lord, whatever, they file an FIR saying that your lordship may kindly see in the next page.
FIR. No, we are testing this order. The
Yes.
order is correct.
Last part of the order has, however, liberty is given to respondent number 5, if so agreed. Because already honorable court has come to a finding that I'm in possession, my
Not finding.
that,
No finding is there.
however, the respondent, your lordship may kindly say page 97.
The respondent number 5 was in position.
If you, how does it offend you?
Because you
Liberty
say,
is given to respondent number 5 if so agreed.
agreement.
If you're not aggrieved, you're not aggrieved.
Yes, ma'am. Now, what happened? He has filed an FIR, my lord. Your next page, your lordship may kindly see. That position was declared to me, my lord. He filed an FIR before the officer in charge of Lamning police station.
I forgot.
For that, I have trespassed into the land, saying that, ma'am.
No. So this is a good enough ground for you to contest the case.
Yes, my lord. Now, what has happened?
Why have you filed the FIR?
No, they have filed the FIR initially.
Mr. Counsel, what is the reason? It cannot be for trespass.
It cannot be for this. I think he was the one who came before the court first, my lord. Lodged the FIR first, my lord.
No, this dispute will continue. The fact remains that you have frittered away the order which was passed in your favor.
Yes, ma'am.
So you ought to have gone to the civil courts for getting your title and everything confirmed.
Confirmation of position.
Now, question is,
Interim measure.
understand well, but now what has happened, my lord? Now there is a status quo order issued by this court, my lord. As a result,
No, we'll finish off all. What is status quo? Nothing is required to be done. But we must know it should not create any further trouble.
that is a
Because if
difficulty.
it's 145, see, you can again start 144, 145. The police report would be the basic report.
Because now
I think on the basis of the FIR, if the police would know their job properly, they would have a report sent to the local magistrate. This is a
Because
dispute
there's
between
a
two brothers.
FIR, counter FIR. I also filed an FIR. They also filed an FIR.
This will continue.
So counter FIR is that now the police has not allowed anybody to take possession of the land, my lord. Presently.
Again, this appears to be the appeal is directed against the judgment dated 17/2/2024, passed by a learned single judge of this court in WPC number 6038 of 2015. In the present case, two brothers are fighting each other for possession of a particular piece of land.
Doing the partition. Is one. Now. It's two.
क्या लिखा है पढ़ो? The respondent number 5 / writ petitioner initiated a proceeding under section 145/146 of the Code of Criminal Procedure, which was registered as MR case number 209 of 1999. The learned subdivisional magistrate, by order dated 3/12/2001, declared the possession of the other brother over the said portion of land, who is the appellant herein. The effort of having such order of possession, such order declaring the possession of the appellant herein, by the writ petitioner failed at every stage. However, in the meantime, the learned subdivisional magistrate, in the garb of executing the order dated 3/12/2001, directed respond number 4, the officer in charge of the concerned police station, to deliver possession of the land to the appellant. This was without any direction by the learned magistrate in the MR case. Such an order was challenged, though wrongly, before in a title suit in which the prayer for injunction was rejected. The learned counsel for the respondent here is not in a position to tell us whether is not in a position to tell us about the stays of the title suit present. The records reveal that after the order of the magistrate was passed in the MR case, declaring the possession of the appellant, nothing was done at his end for having the possession confirmed. In such a circumstance, there could have been no direction by any authority for handing over the possession to the appellant when there was a disclosure about, when there was an adjudication about his remaining in possession all through. It appears that both sides have filed criminal cases against each other. The government, the allegation in both the FIRs not being known to us presently. The learned single judge, therefore, under the facts and circumstances of the case, directed that there could be, in the observe that in the absence of any positive order for delivering the possession of the said plot of land to the appellant, no such effort could have been made by any authority. If at all the appellant, if at all the possession of the appellant was disturbed on any count, he had the option of approaching the concerned authority for the needful. The learned single judge, however, has observed while concluding that the appellant would be at liberty to proceed in accordance with law in case his possession is disturbed or he is sought to be evicted. We do not find any reason to interfere with the aforenoted observation of the learned civil judge. There otherwise also does not appear to be any merit to the appeal stands discussed.
Item 14.
Yes,
My lord, the only issue in this case is, my lord, there was a earlier judgment of this division bench by which, my lord, the issue has been decided. And therefore, my lord, the learned single judge, while deciding this case, my lord, that has not been taken care of. On the basis of a judgment of the Kerala High Court, this petition was allowed. The pension and other retirement benefit of the,
Which is that judgment which has not been taken into account by the impugned judgment?
my lord.
Taken riba.
Yes, I can do.
What does it say?
My lord, judgment is your copy of the judgment is referred. My
Copy is here.
my lord.
No, no. This has not been followed. In fact, it has been taken note of but not followed. Yes, what does Aken Riba say? What was the issue there?
My lord, paragraph 2 of the judgment, my lord, 2 and 3. The petitioner here, namely Aken Riba, Siri Mathian Shoensho and Shoensho,
They are
all
state-
appointed as state commissioner as per the notification dated 3/3/2014 of the Chief Secretary to the Government of Assam, Arunachal Pradesh. The writ petition was instituted in the year 2015, inter alia claiming that petitioners having been appointed, my lord, one copy. Petitioner having been appointed as State Information Commissioner would also be entitled to pension upon retirement on attaining the age of superannuation. One of the arguments set forth by the petitioner is that under the prevailing rules, the State Chief Information Commissioner is paid a pension upon retiring from the service. And accordingly, according to the petitioner, there being no reasonable classification between the State Chief Information Commissioner and that of the State Information Commissioners. Therefore, therefore, to maintain parity under Article 14 of the Constitution of India, the State Information Commissioner should also be declared to be entitled to the pensionary benefit as entitled to the State Chief Information Commissioner. Although the writ petitioner was instituted in the year 2015, but during its pendency, in the meantime, the 4 petitioner has retired from the service in the year 2019. Then your lordship may can be skipped to paragraph 13. A reading of the provisions of CCS Pension Rules 1972 rule would go to show that in order to be entitled for pension, there is also a corresponding requirement of a minimum qualifying service for the persons concerned to have served, and minimum qualifying service would be 10 years. But when he looked at the terms of appointment of the State Information Commissioner, we find that the term appointment is for a period of 5 years, and therefore it has to be understood that the minimum qualifying period of 10 years would not be satisfied in the case of the State Information Commissioner. We have also noticed that under the provisions of the Act 2005, there is no provision for reappointment of the State Information Commissioner as a State Information Commissioner, and hence under the scheme of the Act of 2005, we have to understand that a State Information Commissioner would hold office for a period of 5 years and therefore not meet the requirement of 10 years as qualifying as required under the CCS Pension Rules 1972. The Act of 2005 also provides that a State Information Commissioner may be appointed subsequently upon completing his entire term as the State Chief Information Commissioner, and in such situation, the total qualifying service may be 10 years. But the said issue also need not be gone into, as if the State Information Commissioner is subsequently appointed as the State Chief Information Commissioner, such person would be governed and entitled to
pension as provided in section 16(5)(a) of the Act of 2005. As has already been discussed here in above, and there would be no requirement to include 5 years of service as the State Chief Information Commissioner towards 10 years of qualifying service as the State Information Commissioner. And your lordship may kindly see paragraph 24. In view of the above, we have to conclude that relief sought for in this writ petition for a declaration that the State Information Commissioner are also entitled to a pensionary benefit as applicable to the State Chief Information Commissioner in the state of Arunachal Pradesh cannot be accepted. Although we have arrived at our conclusion that the statutory as well as from the point of view of entitlement of the legal rights of the State Information Commissioner cannot be entitled to the same pensionary benefit as that of the State Chief Information Commissioner, but at the same time, we take note that 4 writ petitioners are and would be the only State Information Commissioner who could be governed by the proposition discussed herein above. That is the commissioner who could be governed by the proposition discussed herein above. The unamended section 16(5) of the Act of 2005, in as much as in future State Information Commissioner that may be appointed would be governed by the amended section 16(5) of the Act of 2005. And therefore, the statutory classification provided in the unamended section of 16(5) of the Act of 2005 would not be applicable to such State Information Commissioner. It being of the Act of 2005 would not be applicable. So although it can be said that any legal rights have accrued to the petitioner for the grant of any pensionary benefits, but we also take note that the present petitioners had some kinds of belief in their mind, resulting in the institution of the present writ petition, that they would be paid some kind of pensionary benefit upon having been appointed as the State Information Commission. From such point of view, although there may not be any statutory, any enforceable legal rights, we request the authorities in the government of Arunachal Pradesh to examine the said aspect as to whether from the equity point of view, the doctrine of proportionality, some acceptable benefit can be given to the petitioner in the nature of some kind of a pension. It was the observation, my lord. The Honorable Division Bench felt that since my lord they did not
Yes, what do you have to say? Even Rekha is something else. We do not know whether they were government employees, whether they were central government employees. Unless you say that they were central government employees.
my lord.
Yes,
here-
you appear for the respondent, Mr. What do you have to say?
These petitioners in Rekarnappa case, they are lawyers, then rich experience and social service holder. They were not in pensionary service.
He was
So
in
he
audit,
cannot be a court-
the respondent here was in audits and account service.
Single judge.
He was
para
paid
16
under the
17.
CCS pension rules.
Yes.
And then 10 years, the slab will not be applicable to him for the reason that by deeming fiction under 16(5) of the RTI Act, he is to be paid his salary. So therefore, the single judge is absolutely right. You don't have a case.
My lord, unamended provisions of section 16(5), my lord. The petitioner was entitled. So for 2019 onwards, my lord.
19, we are not concerned. He was appointed before that.
My lord.
To be governed by the amendment prior to the amendment.
He was appointed, but during the period of service, my lord, the amended rules came into force. My lord.
There is no requirement of any argument on that account. That's understood. It's right. Take down. we have heard the learned counsel for the parties. The present appeal is directed against the judgment and order dated so-and-so 28/6/2024, passed by a learned single judge of this court in WPC 557 of 2023, wherein it has been held that the respondent who retired as State Information Commissioner would be entitled to the benefits and allowances under Section 16(5) of the Right to Information Act 2005 with effect from 1/1/2020. The judgment further declares, the impugned judgment further declares that he would be entitled to other benefits, other additional benefits, namely additional pension, additional DCRG, and telephone and security assistant, which ought to be made available to the respondent. The Union of India has challenged this decision. The state of Assam has challenged this decision on several counts, but primarily on the ground that the judgment does not take into account a decision of a division bench of this court, and that the respondent did not have the qualifying 10 years of service to be paid the additional pension, additional DCRG and telephone and security assistant, which is paid to the Chief Secretary of a state. The respondent was appointed as a State Information Commissioner who served from 31/7/2015 to 31/12/2019. So prior to his engagement as a State Information Commissioner, he was member of the Indian Audit Service and had demoted his office as an OSD in the office of the Principal Accountant General, A&E Assam. Section 16(5) of the Right to Information Act 2005, prior to its amendment in 2019, is extracted herein below. For ready reference, you can take it from paragraph 10 of the judgment, extracted for ready reference. For ready reference, as also for the sake of completeness. Since the respondent was appointed on 31/7/2015, the unamended Section 16(5) of the RTI Act would be applicable in his case. A bare reading of Section 16(5) would indicate that the salaries and allowances of the State Information Commissioner shall be same as that of Chief Secretary to the state government. It appears from the records that the respondent had earlier approached this court by WPC number 4497 of 2021, which was disposed of with a direction to the respondents, with a direction to the state respondent to pass a reasoned order in case of the respondent, in case of the respondent herein, in view of the legal fiction created under section 16(5) of the RTI Act 2005, and not insist for extending such benefit only to a person who has served as chief secretary or in the rank of chief secretary. By virtue of section 16(5) of the RTI Act, a deeming fiction is created to the advantage of the State Information Commissioner, who would be paid similar salary and post-retirement benefits as that of chief secretary. The impugned judgment takes note of the judgment rendered by a division bench of this court in Aiken, Ribba and others. Give the details. Aiken, Ribba and others. 2022, 1 GLT 474. And has rightly observed that the aforementioned judgment does not specify whether the petitioners therein were similarly situated like that of the respondent herein. The respondent herein undoubtedly is a member of the Union Civil Service who superannuated as OSD in the Office of Principal Accountant General. Since he is a member of the Union Civil Service, he would otherwise be entitled to be governed by CCS Pension Rules 1972. Under Rule 49 of the CCS Pension Rules, there is a clear provision that in case of a government servant retiring in accordance with the provisions of the rules, he would be entitled to pension as provided under the said rules. As provided under the said rules. The learned single judge therefore concluded that in case of there being no dispute that the respondent was drawing his pension after superannuating from his services under the union, therefore, there would be no requirement of a further qualifying service of 10 years, which would be necessary for making the respondent eligible for benefits of salary and allowances equivalent to that of the chief secretary by including that of chief secretary. The provisions contained in section 16(5) of the RTI Act referred to above, as also the fact that the respondent had been receiving pension after demitting his office as a member of the Indian Audit Service, there would be no requirement. There would be no reason. There would be no justifiable reason to deny the additional benefits, payable additional post-retirement benefits, which is payable to a person of the rank of chief secretary, only on the ground that he has not had 10 years of qualifying service. The judgment impugned espouses the correct law on the judgment impugned therefore requires no interference. The appeal is dismissed.
Deep level.
We have give your slips. You have not taken your names in the judgment. Heard Mr. So and so, so and so.
Sure, I think.
Give a slip.
Understandable.